Okay, good afternoon. My name's Jeff Consul. I'm very pleased to welcome this afternoon in this conversation Dr. Ray Carter, who is a licensed paralegal, but also an author of Practical Contract Management. And this afternoon, we're going to be talking here about discussing contract law, um, basically looking at the importance of it and the consequences of errors or admissions to the topic. So, very again, this is an interesting topic, Ray, contract law. But if we were to consider the UK and the laws of the UK, what are the origins, would you say, of contract law here in this
Well, that's
country?
a good question. Contract law in the UK has its origins in what's called judge-made law. Most of the law that we, most of the law that abides that controls contracts in the UK, apart from laws of statute, is case law, which you're talking from the 11, from 1066, 1100s onwards. Judges have made decisions about contractual commercial issues, and they have been embedded into our system, and that's what the courts rely on when they're making future decisions. So a court in the UK, a judge will look at previous rulings on certain topics and be guided by those rulings. And it's a very organic subject, so it's always changing. It changes in relation to what's happening, for example, in AI will have a lot of impact on contracts for intellectual property. For example, there's a situation now where there's certain actors who have died, but they've been recreated using AI to appear in films.
Yeah.
A good example recently was one of the characters in Star Wars who passed away, Peter Cushing,
Oh, yeah.
and
Yeah.
the AI was able, the producers were able to recreate his part of the film virtually using AI. And his estate said, "Well, this is not right. He never gave permission for it." So it's a very organic thing, which is its strength, I think, because lots of other jurisdictions are much more regulated. So, like for example, in India, you have the Contract Management Act, which it states what contract management is and contracts are and how they're managed and what the law is. But of course, as times change, that would have to be amended.
Yeah.
It's
No, I understand.
basically judge generated plus acts of parliament, which obviously influence uh, judgments, and international law like WTO, for example.
Mm.
WTO now we have to abide by those laws for public procurement.
So effectively, as a result of this, the law stands there as a unifying a process for ensuring that contracts run in a particular style and a particular way. Here in the UK, obviously, we've got the laws of England and Wales, we've got Scotland and Northern Ireland as well. And are there still some legacy laws that you still utilising from Europe from the time we were involved in the European Union?
I think there's a few. I'm not aware of that many because we have sort of really left the EU.
Yeah.
Um, but no, I wouldn't say there's not on the trading front. I wouldn't say there's very much.
No,
What's
no.
interesting, I think, is the fact that most international contracts will always state that any dispute will be held in London.
Yeah.
So you often find, a Japanese company wants to sue a company in Jamaica. They'll come to London. They won't go to Jamaica, and they won't go to Tokyo. They'll. Then the reason for that, because we have this tremendous depth of knowledge going over hundreds
Yeah.
of years of expertise, and it's one of our big services. It's a big income generator
Mm.
for
Yeah.
the UK economy.
Yeah. Yeah.
For our Because people come here to have their cases heard.
Yeah.
Because they know that we
Yeah.
have the expertise, the barristers and the paralegals and the judges to do a proper analysis and award the contract, award make a judgment based
Yeah.
on good sound principles.
Yeah. Often, I've heard the word reasonableness being used as a defining feature of, law here in the United Kingdom. Um, any thoughts on that statement?
Well, yeah, I mean, back in the past, around 1900, I think early 1900s, the law laws decided there has to be a definition of what reasonable means because it's a very subjective term. What's reasonable to me may be totally unreasonable to you. So it's all based on what the man in the Clapham omnibus would be the man, if like the man or woman in the street that
Yeah,
would believe that would look at something and go, that's not reasonable, or that is reasonable. And that's the underlying principle behind it. And it's used in lots of different ways. I mean, reasonable time, reasonable access,
yeah, yeah,
reasonable availability, reasonable endeavors. I mean, its benefit is its flexibility of interpretation, but that is also its weakness because it can be interpreted differently by different judges.
yeah. And it's interesting because I know the word is used quite a bit in the Sale of Goods and Services Act, in terms of services that are being provided and things
Yeah,
of
yeah.
that nature. But thinking about the world of contracts and procurement, those people who are involved in this in these areas. Um, how important do you think it is to have a working knowledge of the law
Well, I
for
think
these
it's
people?
critical. You're looking at offering acceptance, consideration, where the liability lies. We often come across cases where people say, it's okay, we haven't signed anything yet. And the guys are out in the yard digging the hole or building the wall, and we go, well, sorry, the fact you've not signed anything it does not affect you have a contractual relationship. It might be verbal and undocumented, but it's still in English contract law is a viable contract and you will be held liable.
Mm.
So often people just don't realize that it's like scopes of work. Often, I'll say to clients, you realize a scope of work is a legally binding document. Is it? They say. We thought it was a technical. I said it is a technical statement, but it's what you're offering the contractor to do. And if they accept that offer, they will have to do the work and you'll have to pay them. And
Yeah.
often it comes as quite a shock that to people that that they contracts can be formed, without actually being in writing.
It's interesting because there's a lot of people who are involved in developing contracts, maybe developing procurement activities, and often there's a thought process perhaps that's you know the the uh, the support they may well get in terms of consumer credit law might be prevalent when business contracts are being developed, but that would appear not to be the case. Is there anything you'd like to add in
Well, I think
relation to that?
we're back to the problem of reasonable.
Yeah,
So yeah, under the Goods and Services Act, for services, the service has to be delivered to a reasonable quality, reasonable cost, and reasonable time. Well, that's open to interpretation. Well, what? So I mean, I might say a reasonable time is 6 months, and the contractor might say for us it's 2 years. So really, it's a last result.
mm,
But I wouldn't lead with it. I don't think I would always advise a client to have a contract, properly drafted contract, and get the contractor to sign it before you allow them to commence work or purchase things for you or to do anything really. Because so often people say to a contractor, okay, start work, we want to get this moving, we'll sign all the paperwork later. And a contractor in good faith starts work and then presented with a contract they're not prepared to sign, and then it becomes
yeah,
very difficult
yeah,
because
absolutely.
the contract is already formed, but without explicit terms and conditions.
Yeah, absolutely. I heard the term used quite a bit, caveat emptor. Um, um, any thoughts on that? Because I
Well,
think,
carry emptor is the bias is the seller's first line of defense. As you know, it means buyer beware.
yeah,
So if you don't specify that it's got to fly or sink or be waterproof or whatever it is, the contractor was quite within their right to say, well, you didn't say that it had to do certain things, so it doesn't. That's why caveat emptor is very important in making sure that your requirements are very clear. Because I said, in previous discussions, often the first step in the process is where things go wrong, and that's been in the scope of work. So if it's not complete or things are missing, the contractors were well within their right to say, well, you didn't ask for
yeah,
whatever it is we haven't asked for, so therefore we're not mind readers.
yeah. So,
We're
so
not, we can't be responsible for your lapse and a lack of due diligence.
no, absolutely. And so effectively, therefore, the importance of anybody involved in developing contracts or being involved in procurements, you would say it's pretty essential that they've got this good working knowledge of contracts and how they're formed and
That's
how
right.
they are
But
to run.
what tends to happen, or even if a company has legal counsel, you often find legal counsel is overwhelmed with issues. So the contract managers go, oh, I'm not sure about this, and they'll send it across to legal. Legal then goes into a pile, which really legal work their way through, and that can hold up awarding contracts or signing contracts for weeks and weeks, maybe even months, often over trivial issues. So a lot of the courses that we run are designed to give contract managers and procurement people a working knowledge, so they don't have to keep running to legal for every single issue. They can make a decision on their own, not big legal issues, but minor things. They are confident to make those decisions without troubling legal counsel.
Yeah, that's it's good to hear that that sort of delivery of support is there in terms of what we do and how we go about doing it. Um, so thinking about some of the cases that have historically been in place, are there any things that we can learn from any of these historic cases or recent
Oh,
cases?
there's some recent cases we've been
Yeah,
involved in. I mean, obviously, I've had to change the names because
yeah,
obviously we won't go public on them.
yeah,
But it's a good example of the concept of acceptance. Silence does not mean acceptance,
mm,
but the continuation of action. By your actions, you will be judged. And basically, what happened, the company we were dealing with had issued a draft contract to a contractor. The contractor had made changes to the contract, minor changes, but changes, sent it back. Uh, and it appears that when it was received, the client didn't check it. They just said, "Okay, fine," and put it away. But they didn't accept it. They didn't accept the terms. But then again, they did not reject them. They carried on trading for quite a long while, and of course, eventually there was some kind of dispute. Uh, and the client said, "Well, it's okay because we've never signed this contract. We've never agreed to it, these terms, because obviously it was the change of terms that the contractor was claiming against. Uh, and we had to explain, well, because you've been trading on these terms for the last 2 years, according to the records, de facto you've been accepting these new terms because by your actions you will be judged.
yeah, yeah,
So it's very important that when you
yeah.
have contracts and pieces of paper that you properly sign them and countersign them and send them back and or reject them. Otherwise, if you carry on,
Mm.
you are, as I said, de facto accepting a new
Yeah,
status, a new
yeah.
contract.
Yeah, it's really interesting, isn't it? How things can evolve, by not following, the process or the procedures in terms of, what you might believe to be the appropriate ways of dealing with contracts. So, yeah, I think it's vastly important to have this wider insight and wider knowledge of the sort of issues that can come about through negligence of thinking around
Yeah,
contracts
absolutely,
and,
yeah.
and,
I
and
mean,
the
you're looking
running
at
of them.
big sums of money, big law claims,
Yeah,
uh, you know, big disputes that need to take a lot of that we have to come along and resolve. I mean, we do a lot of that kind of work where we go in and do the sort of Solomon Act and
yeah,
sort of say, look, guys, you're both in the wrong, and often they're both in the wrong because one's not done their due diligence and the other one has not followed the process or whatever it is. But yeah, and of course you can find yourself liable for millions of dollars if you don't get it right, or you don't tick the right box, or you don't make it clear what you are liable for, what the contractor's liable for. These can be, quite big contractual disputes that can arise from
yeah.
people not understanding, the basics of contract law.
Yeah, absolutely. Now, certainly in your role as a paralegal, then you can help, can't you, in terms of
Oh yeah,
and
yeah,
any
yeah.
disputes or any
Yeah.
issues,
Well, the things,
resolving
yeah.
issues.
I mean, we have a team of paralegals, we have solicitors, and various other legal. We have KCs, barristers, I should say, who don't work for us, but they're on our books, and we have a relationship with them, which is the way it works in the law. Obviously, we have chambers that we deal with, um, and we can give lots of advice, lots of opinions. Um, we can help with contract drafting. We're often asked to review contracts. Client will come and say, "I've been given this contract to sign. Is it okay to sign it?" And we'll go through it and go, "Yeah, it's okay." Or, "Well, maybe I would take this clause out, or I would
Yeah,
challenge that that liability that you're signing up for. So yeah, we can do the training side where we
Yeah,
empower people to do it themselves,
yeah,
but also we can give hands-on
yeah,
advice
as
because
well.
we're licensed
Yeah,
by now. We have an official license.
to,
I'm licensed to give advice and to give opinions and to help people with their, but only in contract law.
yeah,
I can't do weddings and funerals and
no,
what
no,
not domestic. It's
not
only
domestic. It's only
not
contract law.
domestic.
Yeah,
Only in contract law. Yeah.
yeah. So if I was to, talk about, courses that you could run on contract law, are there any specific areas around contract law that would be key as a course that, you'd be able to provide to?
Well, the courses that we run, we tend to go through the whole process. We tend to start with offering acceptance and consideration,
Mm.
uh, looking at misrepresentations, looking at caveat emptor, looking at liabilities, indemnities. So we pretty much cover the full program. I mean, obviously, it's not a law degree, which takes 3 to 5 years.
Yeah,
So it is a sort of fast and furious. But as I said, if you're a contract manager or procurement manager, and it's almost you need to understand what you should not be doing as well as what you should be doing. And you might say, this sounds a bit more complicated. I better go and contact legal. So it's
yeah,
almost like again, as I said, giving them confidence to deal with the routine matters, but the really sophisticated stuff, they need to refer to legal,
yeah.
refer
Okay.
to counsel.
Yeah, I understand. Well, I think we've covered off quite a bit in this in this conversation on contract law, and I do thank you for your time and explanations that you've given, Ray. So once again, thanks very much
My
for uh,
pleasure.
for
As
doing it.
usual, or as always, my pleasure, Jeff.
Yeah.